Well, we've talked about a lot of cases in this course, and that, of course, is because administrative agencies get sued a lot. And so in this case, we're going to be examining some fundamental principles that govern lawsuits that are brought against administrative agencies. First, we're going to talk about the timing of judicial review. This seems kind of esoteric, but it is really important about when a lawsuit is brought against an agency. And in this section, we're going to talk about the related concepts of mootness, ripeness, and the Exhaustion Doctrine. So, what are these all about? Well, these are actually all ways to avoid judicial review. Frankly, courts don't want to hear most lawsuits against administrative agencies. They don't want to hear most lawsuits. Lawsuits are inefficient. Courts are overwhelmed with business, so to the extent that they can have cases be settled in some other way without coming to court, that's what they'd prefer to do. Now, as we go forward, these may seem like very technical issues, but they are not. They are political. If the court wants to hear a case, it can hear a case. If it doesn't want to hear a case, it can use some of these mechanisms to get rid of the case. And as we go forward, hopefully you'll see some of the political implications. So first, let's consider mootness. Mootness is a pretty easy doctrine to understand, and it's based on the fact that lawsuits just take a long time. If you've got a complicated lawsuit, a trial can take years. You've got the preparation for the trial and the trial itself. And then, of course, you've got the round of appeals, and that can take years. It can take years for a case to make its way to the Supreme Court. And sometimes, as a lawsuit is going on, the facts will change. Something will happen that makes the original dispute no longer relevant. The original dispute no longer exists, and it goes away. And as a result, the court will often find that the case is moot and dismiss it because there's no practical effect of their decision. Now, a classic example of this is the 1997 case, Arizonans for Official English v. Arizona. In this case, the voters of Arizona had approved a ballot initiative that required all public managers, actually everybody that worked for the state of Arizona, had to conduct all of their business in English. English was the official language of the state of Arizona, and so all state employees were required to speak English. There was a public manager who worked with a lot of Hispanic clients and spoke Spanish a lot on the job, and she filed a lawsuit claiming that this law violated her First Amendment right to freedom of speech. Well, of course, this lawsuit took a while to make it to the United States Supreme Court, and in the meantime, she actually quit her job and she got another job in the private sector. And so when this case came to the Supreme Court, the court dismissed it because they said that it was no longer moot because she was no longer working for the state. Now, it's interesting, if she'd gone to work for a different state agency, then the case would not have been moot, and presumably the court would have had to have decided it. But she left government employment altogether for the private sector, and so it became moot. Now, the interesting thing, of course, is yes, it's true that that particular dispute became moot, but does that mean that the legal issue itself was moot? Of course not. There clearly were other individuals working for the state of Arizona who had similar concerns, but of course this was simply a way for the court to avoid the issue, but to uphold the law without actually making a ruling. So of course there is a practical impact of any of these particular decisions. So ripeness is interesting because it's sort of the flip side of mootness. Mootness is a case that's brought too late, if you will. Something's happened, the case is no longer relevant, it's too late. Well, ripeness is the doctrine that says the courts will not hear cases that arrive too early. And both ripeness and mootness stem from the Constitution's requirement that the court only hear cases and controversies. And so if a case is too early, if it hasn't formed enough yet, then there's no controversy, or if it's moot, then there's no controversy. So what does this mean, that a case has to be ripe? Well, usually what it means is that somebody has to have actually been injured in some way before a lawsuit can go forward, that they cannot simply allege a hypothetical or future injury in order to bring a case to court. A great example of this is the case of National Treasury Employees Union v. Von Raab. And this emerged from the 1996 attempt to give President Bill Clinton a line item veto. And in fact, you have in this class read Clinton v. City of New York about the line item veto. This was an initial challenge to the line item veto. A union thought that this law was unconstitutional, but the problem was, although the law giving President Clinton the line item veto had been passed, at the time this lawsuit was filed, President Clinton had not yet used the line item veto. So it was completely hypothetical about how he might have used it and how it might affect the National Treasury Employees Union. In fact, of course, the court did ultimately decide that the line item veto was unconstitutional, so it did ultimately hear a case, but it only did so after Bill Clinton had used the line item veto, and then the City of New York challenged it because they had lost some funding, and so the case was ripe in that instance. However, none of these rules are absolute. For example, sometimes the court actually does hear moot cases, such as abortion cases. Pregnancy only lasts 9 months, and it often takes longer than that for abortion cases to work their way through the system, and so the court will sometimes make exceptions. That's also true in ripeness cases. It doesn't make any sense in some cases to make a party suffer an injury before they can file a lawsuit. For example, if somebody has been sentenced to death, well, it doesn't make any sense to kill them and only then allow them to file a lawsuit. So sometimes the courts will hear cases wherein somebody has not yet been harmed if the harm is grave enough and if it's imminent enough. A good example of this in the regulatory context is Abbott Laboratories v. Gardner, decided by the court in 1967. And in this particular case, the Commissioner of Food and Drugs had issued a new regulation regarding the labeling of drugs. So drug manufacturers were going to have to change their labels. And a group of drug manufacturers, including Abbott Laboratories, sued. And they did so before the regulation actually took effect. The government asked the Supreme Court to dismiss the case, saying that it wasn't right because the regulation hadn't yet been enforced. The case wasn't ripe and it should be dismissed. The court disagreed. They said, well, yes, it's true, it hasn't taken effect yet, but if we do not hear the case now, this will put the drug companies in an untenable position. The court said, if petitioners wish to comply, they must change all of their labels, advertisements, and promotional materials. They must destroy stocks of printed matter, and they must invest heavily in new printing type and new supplies. The alternative to compliance may be even more costly. That course would risk serious criminal and civil penalties for the unlawful distribution of misbranded drugs. So the court is saying that essentially this regulation, even though it hasn't taken effect, it's already putting these drug companies in between a rock and a hard place. They've got two terrible choices to make, and only us clarifying these issues can avoid that situation. So Ripeness is intimately connected to the concept of exhaustion as well, because according to the Administrative Procedure Act, judicial review is only available after final agency action. So if somebody has a complaint with your agency, if there's something you have done or something your agency has done, before somebody can go to court, they have to exhaust all of the available legal remedies that the agency may have for them, and this is known as exhaustion. And the Exhaustion Doctrine, once again, is an attempt to preserve judicial resources. The courts don't want to get involved in disputes if they don't have to, but it's also a way to encourage litigants to use the various procedures that the agency has available and to give the agency an opportunity to correct its own errors before it goes to court. So if an agency has some appeal procedure or some other way of dealing with your grievance, according to the courts, you have to use all of those avenues before you can go to court. Now, your book contains 3 different cases on this, so I don't have much more to say about it, but I would encourage you to read these cases, which are interesting. The first is Woodford v. No, which arises in the prison context, an appeal of a prisoner's punishment. And you've also got McCart v. U.S., which deals with the requirement to register for the draft from the 1960s. And there's also Sackett v. EPA. We're going to be talking about the EPA a lot in this particular set of lectures, but I urge you to take a look at all 3 of these cases and what they have to say about the timing of judicial review.